Calling the third case in our list, SJC-12136, Sean Gannon v. City of Boston.
Good morning. We'll give you an extra moment because we know that we moved you up one in the queue, but you're ready as always, I'm sure. All right, you may proceed.
I would have been ready for 15 more minutes. May it please the court, my name is Harold Lichten. I have the pleasure of representing Sean Gannon. I think it's clear beyond doubt that the court applied the wrong legal standard and framework in analyzing this case. And I think this court could reverse that decision based solely upon that clear and reversible error. There were plenty of facts that were disputed that would be sufficient to prevent the granting of summary judgment were the proper standard applied.
Can I ask you a simple sort of initial question? I was a little confused about this.
Sure.
What is it? Is it that plaintiff is impaired? Do you say that your client is impaired or not, so that it's handicap discrimination that you're alleging?
Yes.
Is it just perceived as handicapped? I'm a little confused.
So the definition of handicap under the statute can be shown in three ways. One is an impairment which substantially limits a major life activity, and we're not saying that. One is having a record of that, and he does have some record of a functional impairment. But the third, and the one we're relying on here, in which the court found, was that they regarded him as having an impairment which substantially limited major life activities, just as the court found in Dayhill versus Boston Police Department, which is a very similar case in which the police department denied a police candidate graduation from the police academy because they thought his hearing prevented him from doing certain tasks, and the court found that there was at least an issue of fact as to whether they regarded him as having a substantial limitation.
But see, that's what confused me, because in that case, there's no question that his hearing was impaired. It's a question of what effect it would have on his ability to do his job.
Well,
here, I thought that there was some question about whether or not he was impaired.
Well, there's no question that he's had some concussive injuries. We do dispute, because we don't know what his premorbid state was, that is before he had, because we don't know that any of the findings they found were in fact things that didn't exist in the 10 years before he had those concussions and performed his police jobs well. But they clearly, Justice Lang, to answer your question, they regarded him as having a substantial impairment, and the lower court found that there was sufficient facts in the record from which a trier of fact could determine that they regarded him as having a substantial impairment. If you look at the record, which we've cited to you, their psychiatrist, who we don't think was qualified, doesn't say just that he couldn't be a police officer, and I'm quoting now, she says in her report, "These mental deficits interfere with his ability to make accurate assessments and judgments and solve day-to-day problems effectively, even when not under stress." She goes on to state, "Mr. Gannon has a serious chronic mental disorder, as well as a history of repeated head trauma. Despite multiple and complex medication regimens and changes, he has improved only moderately." In other words, there's sufficient evidence in the record. Now, maybe we'll lose a trial, but there's certainly sufficient evidence in the record that they regarded him as having substantial cognitive impairment. And that's what the lower court found, that there was evidence in the record from which a trier of fact could determine that. Yes.
Can you just lay out for me that if you go the route, which I think you agree with, that the MCAD's approach to this kind of case. So you have your prima facie case, your client's prima facie case, is to show that he is qualified for the position.
Yes.
Despite, either with or without reasonable accommodation.
Yes.
And that's a fairly non-onerous burden, you would say?
Well, yes, here's what I think the burden is under what I call the Pushkin or direct evidence cases, and this is supported by the federal cases and the MCAD, and I think you support this in Cox versus New England Telephone to some degree, where you say we should
Yeah, although it's, that,
That's a little different.
well, let me just, could I just
Yeah, sure.
segue and just ask you that question about the difference? Because that, Cox goes forward on disparate impact. I mean, it sort of looks at it as a disparate impact case.
You know, it says that, but that's not really what happened. In Cox, unlike here, they actually had him doing training on, that was my case also, climbing poles, and he failed the pole climbing part of the course. The lower court at trial found that that was an essential function of the job and that functionally he couldn't do it. We tried to argue that they should have accommodated him because it wasn't an essential function. But
So even though they said that, that's not what they did, this court.
I think that's right.
So
Okay.
back to this case.
So I think the burden, and while we're on that, I just want to say, in that case, unlike here, they functionally tested him. In this case, what's shocking is the police department that has the best laboratory in the world.
We're going to get
Okay.
there. I get that.
The standard, I think, is as follows. First, the plaintiff must show that he has a handicap as defined under the statute, which would mean regarded as. Secondly, he has to show that he's a qualified handicapped individual. That means with or without reasonable accommodation, he is capable of performing the essential functions of the job.
So in this case, that all the medical evidence that you put in meets that?
Yes, and the court found that. The trial court found that there was more than ample evidence, and we had a number of experts, both lay experts who did police training who tested him, and neurologists and neuropsychologists. Then the burden...
I'm sorry, before you get there, and I want you to, but you're saying that the prima facie case means there is evidence which, if believed, would support a finding.
Exactly, Your Honor. As far on summary, right, on summary judgment.
Okay, so that's the first step.
Yes. Then the burden shifts to the defendant to show that he's not otherwise qualified for the job. That is, he's unable to perform the essential functions of the job. And if there's evidence in dispute on that fact, it would go to trial. But then, and this is, I think, the important point that goes to what the department is arguing, they have an affirmative defense, too.
Yeah, right, you're going to get there.
Yes,
That's later, in the order of things.
it's the last part of the order.
So in the order of things, we're at step 2.
Right.
And step 2 is they need to put in some evidence that, if believed, would show he's not a qualified.
Exactly, exactly.
so-
Or we would be entitled to summary judgment, right,
Okay.
right. And then even if they put in, even if they're not successful at trial or at summary judgment in that evidence, they have one more thing, an affirmative defense that they may utilize, which is particularly apropos for public safety cases, and that is the so-called safety defense. And they have to show, to a reasonable degree of probability, that if allowed to continue working or to hire him, he would injure himself or others. That's called the safety defense. It's in all of the MCAD decisions.
Right, that's where my question is. Okay, so we've got your 2 prima facie cases.
Right.
Then you have the burden of showing that you have the burden of persuasion, that the evidence persuades you that despite what the department says, your client is qualified to perform as a police officer.
Yes.
And is it at that point that this affirmative defense comes in?
Yes, I think it's the last step in the process that if the...
At trial, we're now talking at trial. We're not-
Or I would argue, to be fair to the department, that if they had overwhelming and unrebutted evidence that if allowed to perform the job, let's say the person had chronic macular disease, so it would be clear that in 6 months that person would go blind, they would be able to show, well, okay, maybe he can be a police officer now, but it's virtually certain that he could not safely perform the job of a police officer because he couldn't use a gun if he was blind. So I think that's something that could be decided on summary judgment, but certainly would be decided at trial. And it's not a risk, because if you use a mere risk standard, every handicapped person is going to be slightly more at risk. Someone with epilepsy, someone with diabetes. You would gut the handicap discrimination laws. So the courts have wrestled with this. The federal circuits under Section 504 of the Rehabilitation Act that our statute was patterned under have come up with this reasonable probability test. And that would be an issue to be tried at trial, whether if he can perform it now, whether in the future he would pose a risk to himself or others. Now, they didn't raise that here, and the court never got to that because the court went off the tracks when he applied this McDonnell-Douglas framework.
Let me ask you that, just a real simple question. It might be a complicated answer, but it's a real simple question. It's a discrimination case, and you're saying that there's no requirement for there to be discriminatory animus.
Exactly, Your Honor, and the reason for that, and this is from the 10th Circuit opinion in Pushkin in the 80s, and it's been followed by every court that's addressed this, handicap discrimination, unlike race and sex and other types of discrimination, is never based upon discriminatory animus. I don't like you because you're handicapped. Rather, as the 10th Circuit says, it's based on the mistaken belief that people with disabilities or perceived disabilities can't perform like others. And when you look at the statute, 151B, Section 416, it reads completely differently than the race and sex and national origin discrimination. It says that you cannot deny a job to a person who is capable of performing the essential functions of the job. There's no animus involved in that, and that's what the courts have held since Pushkin. The best example of that, Your Honor, is the case we cite, Rizzo versus Children's World. It's almost identical legally. There, the defendant said, we didn't deny this person a job as a children's bus driver because of her hearing impairment. We denied it because we don't think she could hear screams in the back of the bus if a child was choking. And that's a legitimate non-discriminatory reason, which is exactly what the court found here. He found, I believe the police department, that they denied him the job because they thought he was neurologically impaired. But as the Fifth Circuit says, and as the MCAD says in its regulations, that's not a legitimate non-discriminatory reason. That is a reason based on the handicap. And the focus in that situation is whether the person is capable of performing the essential functions of the job. The thinking of the department or the thinking of the employer is irrelevant to
So
cases.
if you were to take your case and distill it down to one sentence, it would be that if Judge Wilkins had applied the appropriate standard, there'd be a genuine issue of material fact.
Yes, and that's exactly correct. And I think he did make the first two findings, and I think since the department didn't raise the fourth affirmative defense, which I think would be hard to prove on summary judgment anyway, it's clear that if he had followed the right standard, which the MCAD and all the federal cases and state cases say should be applied, he would have said that I can't grant summary judgment, it should be remanded for trial.
However, in this framework, I'm just going to call it the modified Pushkin framework.
Okay.
It would seem to me that summary judgment is going to be virtually impossible.
I disagree. I think there are many cases, and you know, I've been in this area for a long time. There are, for example, I'll give you, if they had simply, one of their concerns that they expressed was that Sean Gannon would be a risk to fire a gun, that he couldn't fire a gun properly. They have a firing range there. If they had given him functional tests that tested him, and he didn't properly pass job tests that had been functionally found to be related to the job, I think they could have gotten summary judgment.
Well, as a practical matter, as long as there's an expert on the plaintiff's side, there won't be summary judgment.
Well, I disagree. I think
Because they could have done that firing range case test or scenario, then you have the Spartan, whatever that group was, who said he was fine to fire a gun under a situation.
Well, but they
there's
never-
there's an issue of material fact, right?
Well, but they never tested him. If they had done the type of testing that they do for all of their cadets before they allow them to be police officers, and he simply didn't pass, and this was a functional requirement that they had in place for many years, and he was below it, and they showed that they had studied the job, and he fell below it, I think I would have had a hard time on summary judgment.
You had your guy say, I gave him all these tests, this is what defines the position, and he did just fine?
Yes, exactly.
Because they get a little up because they run the
Are you gonna
department?
Are you gonna stick with that position down below later on?
What?
Are you gonna stick with that position down below later on?
Yes, I'm going to stick with that position.
Because
And
we-
that raises
Because we
the-
do videotape. I'm a little bit perplexed by the affirmative defense.
Yes.
When you speak about it being a reasonable probability, is that different from a preponderance?
No, I think that's exactly what it is. I think a reasonable
preponderance
probability
of the
means you
evidence.
have to show that it's more likely than not that the person would injure themselves or others if allowed to perform the job.
And what perplexes me is for the job of a police officer, how can you say that he is qualified if I mean, I'm not saying in this case, but theoretically, how could a police officer be qualified if it were more likely than not that he would pose a substantial risk to himself or others? Why is that not part of the qualified handicapped person standard?
Well, because the way the courts look at it, I see your point, and I agree with it, but the courts look at it, a person might be presently able to do the job. They're standing before you. There's, like I said, the person who's going blind in 6 months. But there may be an argument as to whether or not he would be able to do the job in the future if allowed to continue in the job or fired. And that requires, because most disabled people have some risk involved, and you have to quantify that risk, and the courts have come down on the reasonable probability standard.
So this is a macular degeneration type standard, is that you can see now, but with macular degeneration, you're not likely to see in the future? That's how you would employ it in that kind of case?
Yes, or given this type of injury, we know from statistical science that most people with this condition aren't able to fulfill these certain requirements which have been linked to the job. If I might just say before I close, because I want to get at that, the MCAD regulations in the brief of Mila, which I think is very important, talk about the fact that the department is free to have functional requirements. In fact, it should be encouraged. They should have their standards that are required of police officers by studying the job of police officer and then implementing those standards and then testing those people to make sure they meet the standards. We all want that, and that's perfectly legitimate. That's not what happened here. They never actually tested him about doing the job when they could have. Instead, they relied on some neuropsychological tests that are pen and paper tests, drawing colors, drawing trail lines. And in fact, there's a lot of conflicting evidence about, on some he did very well, on some he didn't do very well. We don't know what his condition was before. We know he had attention deficit order from being a young person, and therefore, they never functionally related those tests to the job of a police officer when the functional tests they could have done were right in front of them.
Thank you.
Thank you very much, Your Honor.
Ms. Taub, good morning.
Good morning. Chief Justice Gans, Justices of the Court. May it please the Court, Nicole Taub here today on behalf of the City of Boston. As it's clear to the Court, I'm here on behalf of the city to ask that you affirm the decision of Judge Wilkins in the lower court decision in this matter, finding that the department's reliance on objective test data, which undisputedly showed that the plaintiff in this case tested in the 1st to 5th percentile when specifically looking at response time, was a legitimate non-discriminatory basis for his placement on modified duty.
Why do we even get there? I think I'm really puzzled about how it is that Judge Wilkins decided that the McDonnell-Douglas test should be applied in this case. I mean, you've got direct evidence of discrimination here because the police department is saying that this person has a handicap that prevents him from doing the job outside of the desk that he's been sitting at.
So I'd like to take that in two parts, if I may, Justice Hines. The first is the department maintains that it did not, for purposes of protection under 151B, perceive the plaintiff in this case to be a qualified handicap person.
I mean, that's just not, you're saying the sky is green when everybody can say it's blue. They're perceiving him as having a handicap. Otherwise, he'd be on the street with a gun, right?
I disagree, because when you're looking at the definition of perceived handicap...
not definition. If the department did not perceive this individual as having a handicap, he'd be out there with everybody else, right?
Perhaps, but it's not enough to have
Perhaps?
but it's not enough to have a handicap. You have to establish that in the context of the employment or in the context of that handicap, you're substantially limited in a major life activity. And that's where we maintain that he is not. He continues to come to work, he performs certain functions, and even if you apply the major life activity of memory and thinking, as my brother has put forward, there's nothing to indicate in this record that if he doesn't have that
Why is the department treating him the way that it does?
Because the department has significant concerns regarding his abilities in the area of response time. And as the court concluded, that's not the reason for its action. That is the basis for its concern, and the reason that the plaintiff has those limitations is not relevant for purposes of this analysis.
But police officers, most police officers go out in the street and they're armed with guns, right?
True.
You won't let him do that, right?
That is true.
But you say that's not a handicap?
I would suggest it's not one warranting protection under the law. And to go to the second element of your question, I disagree that this is a direct evidence case. Direct evidence is such that unambiguously establishes a disability discriminatory motive. It assumes some kind of inappropriate or egregious animus on the part of the employer in taking its action.
Well, that's not correct. I mean, at this stage, all you're showing is that this person is being treated differently, right? I mean, the animus is going to be relevant at some point, but for direct evidence purposes, all the plaintiff has to show is the act of discrimination.
They have to show, for purposes of direct evidence, that it is absolutely unambiguously discriminatory motive. You can't look at the external factors. It's not sufficient to just point to the fact that the department identified.
Don't you show motive later at the later steps in this analysis? The first step is to show that you're a qualified handicapped person and you're being treated differently because of that. Never mind why the department does it. You get to that at a later stage in the analysis.
Well, but I would suggest, and I'm presuming that you're using this Pushkin analysis, in order for that to be the appropriate analysis, you have to establish that the action was based on direct evidence of discrimination, which is that unambiguous.
Discrimination out of it.
I find that difficult to do, Justice Botsford, given that that's in the court's definition of direct evidence. It's unambiguous disability discrimination motive. So it's difficult for me to take that discrimination piece out when that's what the courts have told us you need to justify that standard.
Discrimination in that context then means your perception of the disability is outmoded, misguided.
So let's talk about misguided, because I think that brings us to a good place. As the MCAD tells us in their brief, one component is that the burden rests with the plaintiff to show that the actions on the part of the employer were not based on misguided assumptions or incorrect factual conclusions.
The last step.
That's the last step, which I would suggest is akin to the analysis that's conducted when establishing whether or not the stated reasons are pretextual. And for that reason, I suggest that even assuming, which I do not concede, that this is a case of direct evidence, you come to the same conclusion, and here's why.
Are you saying that if you apply the Pushkin-type test, that you come to the same conclusion?
I am, yes.
And that on this record, you get summary judgment?
Yes, I am.
Okay.
And here's why.
Could you explain that, please?
Yes, of course. Given the plaintiff's own expert, Dr. Neil McGrath, who has identified on this record that the plaintiff scored in an impaired level when tested specifically for response time. He scored in the 4th percentile and conceded on page, 747 of the record. Scores in this percentile are troublesome when considering when an officer can be returned to full duty, and there is no reason to dispute these scores. And that's incredibly important here because the lower court spent a lot of time talking about the objective test data. And what you have when you look across the 4 experts that conducted testing of the plaintiff in this case, 2 on behalf of the city and 2 on behalf of the plaintiff, they all came to the same conclusion, that when tested for response time, the plaintiff scored slower than 96 to 99% of the population.
You don't know his baseline, though, right?
I don't know.
Isn't that a problem?
I would suggest that it's not. I think what we're talking about is in these circumstances which were caused by an action separate and apart from any disability or potential concern of disability that prompted these tests. The plaintiff failed to report for work as scheduled. He was found disoriented and
But we're
confused in
talking about
his home.
We're talking about his neurological deficits, and wouldn't you agree that unless you know one's baseline, we don't know where the person started and where they ended up?
Well, certainly you don't know if you don't know the baseline, but what we do know in this case is that the police department, for purposes of pre-employment, conducts both medical and psychological screenings pursuant to the state Human Resources Division's guidelines. The guidelines are in the record. Part of that testing encompasses these types of impairments. So one can presume, for purposes of what we have on this record, that there was no reason for concern that the plaintiff was impaired up and until this testing began following his failure to report for work and the condition in which he was found at his home.
Does the police department require this response time testing for all persons trying to join the department?
This specific type of testing is not done at pre-employment, but the department does require of all of its officers, and as this court has affirmed, they are expected and required to make everyday snap judgments.
Well, I understand that, but it's not as if you say every police officer must pass this response time test to become a police officer. You gave him this test only because you had concerns about the concussions.
Well, it wasn't so much concerns about the concussions. It was the overall concern given the condition he was found in and the subsequent evaluations. But
doesn't that mean that you gave him these tests precisely because you thought that he had suffered previous injury which rendered him somehow disabled in terms of his ability to make decisions?
perhaps a distinction without a difference, but I would suggest these tests were administered to ensure that he could safely perform the essential functions, which explicitly and undisputedly involve speed and accuracy in the course of the everyday.
Your concern about whether he could perform safely arose only because he had appeared disoriented and you thought that they may be a symptom of the concussions he suffered.
Potentially, yeah, because he was found disoriented. That was the impetus for the testing.
But let's assume that that is sufficient. Let's assume that there's at least an arguable basis for that. Isn't that enough for them to say you viewed that as a disability, which is what caused you to give him this test, which you now say demonstrates that he is incapable of performing his job?
No. I don't.
Where is the flaw in that?
What the department is saying is that there's a very specific responsibility associated with the job of policing.
We all agree. We all agree. We all agree that being a police officer, you carry a gun, you need to make quick responses. We all understand that. The question is not whether that's not true. The question is whether or not you need to prove it at trial by a preponderance that he can't do this job without putting himself and others at risk and therefore cannot adequately perform the job, or whether or not your good faith belief that he can't do the job is sufficient. Isn't that really what this is about?
I think it is, and I think as the lower court identified, given the significant amount of objective test data, specifically on the question of response time, undisputed across all four experts, and the clear nexus between response time and the job of a police officer, that objective data was enough for the department to make its decision to place the plaintiff and maintain him on modified duty. A decision I also will just note as an aside was determined to be reasonable in arbitration, articulating a lot of the same facts that we're discussing here today.
But if the appellant had a chance to talk again, what they would say is, no, Dr. McGrath was a little less certain than he was in 2012, but his ultimate opinion was still that he was reasonably fit to return to full-time duty.
I'm glad you raised that point, because I also again would ask that the court turn its attention back to Dr. McGrath's testimony on that very point. There's no dispute Dr. McGrath did an initial evaluation of the plaintiff that didn't involve any objective testing of his own. It was a simple review of the papers and a meeting. Based on that, which you also, based on a review of the record, will see, was missing significant testing data that had been done up until that point regarding the plaintiff. So based on an incomplete record and a lack of his own testing, Dr. McGrath concluded to a reasonable degree of certainty that Officer Gannon could perform the essential functions of the job.
In summary judgment.
But if you then go back and look at his subsequent statement, where he affirms and takes no issue with the objective testing done by all experts up until that point, including the scores between the 1st and 4th percentile on response time, he suggests that Officer Gannon is most likely fit to perform the functions, but that some additional type of testing is required. But when asked, what is your support for requiring that testing? Is there a scientific basis? He says no. When asked, what does that testing look like for you? He says, I don't know.
Counsel, what you're suggesting is that that's the dispositive fact in the case and that there's nothing else that should be or would be considered. But counsel for the police officer says, well, that's not the end-all and be-all because we don't really know what this person can do because they never really tested him in a real live situation. This is a paper and pen test that was done. So it's summary judgment. You know, you may win at trial, but it's kind of hard to close the door where it's not exactly clear that this is the one test that can separate a person who's qualified to be on the street from one who isn't.
I would suggest it's not one test. I would suggest it's testing done by 4 qualified experts with nothing in the record to dispute the validity of the objective data from those examinations.
That may be true, but I'm sure that the plaintiff wants to argue that that's not the litmus test for whether I should be permitted to be on the street with a firearm.
Certainly, but that's not a question for the plaintiff. That's a question that the court answered when it found that the department's reliance on this objective data.
That's my point. The court maybe shouldn't have done that if that's an issue that the plaintiff is entitled to dispute.
But I would suggest it was, in fact, appropriate for the court to do that, given the overwhelmingly objective data presented in this record.
But the judge himself said that as to the question of whether he's a qualified handicapped person, there are issues in dispute.
Yes, and without much.
But you're saying, okay, well, there are issues in dispute whether he's a qualified handicapped person, but because the police is acting on a good faith belief supported by medical evidence, it wins.
Yes, and the judge, I think, doesn't spend a lot of time flushing out the prima facie case that is the plaintiff's burden here and moves to the department's burden and very significantly establishes that the department's actions were appropriate.
The problem I see is that if a good faith belief by an employer, supported by some medical evidence, albeit disputed, is sufficient to say that I need not hire a handicapped person, that fundamentally changes it to not from a preponderance test to a good faith test.
Well, I don't necessarily see that as what the court did here, and I see that I've run over, but I would just to address that point. What the court did here was looking at the undisputed and very consistent data across all 4 experts, including the plaintiffs, that Officer Gannon, when tested in the very relevant area of response time, scored slower than 94 to 99% of the population. While I would agree that reliance on a medical expert does not necessarily insulate an employer from liability, in this case, given the undisputed nature of the test, the undisputed credentials of the experts that gave that data to the department as part of its decision-making process, and the direct correlation between response time and the duties of a police officer, somebody who scores slower than 99% of the population should not and could not in these circumstances be handed a gun by the police commissioner and sent out on the street to enforce the laws in the city of Boston.
All right, thank you.
Thank you.